Good evening, this is Laws 12062, Alternative Dispute Resolution. We're into week 10. We're down to the business end. Next week we have a substantive online session. That'll be our last for the term. Other than that, we'll be discussing matters through UCRU. Speaking of UCRU, today I released last year's second assessment piece. Do have a look at that. I decided to release it because in many ways it's similar to what you'll face this year, sufficiently similar to warrant putting it there. But it certainly won't be exact. But there will be a requirement for you to make your response to me as real as possible. So the idea of the first assessment was I wanted something real. Second assessment, I want something real, but it's not audio-visual, it's in writing. So the same sort of thing. If you can get out and about, if you can make something that involves contact with actual practitioners, so much the better. You don't have to. If you don't, that's fine. You'll still be every chance of getting through. But if you really want the good marks, you're actually going to speak to people. So think about how you might do that. Have a look at the list of different ADR options that I keep coming back to. It's on about page 3, I think, of your text. And think about who you might contact in relation to those different types of mediation or ADR practices, rather. Tonight is mostly me talking, but having said that, I do encourage you to please contribute, ask questions, simply unmute your microphone and ask live, or ask through the chat facility. Tonight, my focus is really about providing feedback on Assessment 1 and at the same time providing you with some guidance on Assessment 2. Our structured week this week is in relation to Chapter 9, Ethics and Standards. I think that's pretty comfortable reading. I'm not going to rehash that for you. As I said to you last week, I think you can read that just as intelligently as I can. So there's no need for me to point out issues there. But I will ask you to do a couple of things based on this week's reading, Chapter 9. The first is think about your ethical obligations in the context of you advising a person who is involved in the ADR process, and think about your ethical obligations as an ADR practitioner. The second thing is think about the accreditation regime. Think about what it would take for you to be an ADR practitioner in an area of practice that's of interest to you. So think about those things and read actively while you're reading the material. I guess finally I should indicate that you should read Mullen's case if you haven't already done so. If you have any questions, please jump on in. So, feedback on Assessment 1. I'm a pretty hard marker, I appreciate that. But overall I was really happy with the work. So if you got an average grade, don't think that that's not good. It's really quite good because I think the average was overall very good. And I did like the work that I got back. Can I just say that, and to some degree this is subjective, so there was a reasonable chunk of discretionary marking in my marking regime on this assessment. But ADR is a bit like that. ADR, there's a bit of acting involved in this. It's a matter of how you feel about things. Because, and this is really important, and I'm quoting now from Professor Adrian Ashman, who provided me with some guidance when I went to QCAT. I'd been trained as many times before, but he really said something that was great. And he said, if you're going to be successful in the mediation or conciliation, then you would like to think that the participants feel as though you are their new best friend. And that is something that is really a feeling that you might get when you look at the material. So the art of mediation requires you, and I'm talking about mediation and conciliation, and ADR generally, it requires you to be dynamic. You need to have a lively approach. Now, you might say, well, why do you need that? Well, my response is that if you're going to be friends with someone, let's go back to that whole thing about body language. you need to make a connection. And, you know, if you go to a good concert, you go to a Bruce Springsteen concert or whatever it might be, there's a real connection there. And that's the same sort of thing that you're looking for in ADR practice. And that's kind of a feeling that you might get based on what people are doing. So it means that you're working very hard to assist the parties, but you're very relaxed at the same time. And that's a bit of a skill, because your focus must be on the parties, and you're trying to assist them as much as you can. You're trying to coach them, you're trying to encourage them, you're trying to provide some reality testing at the same time. So it's not just all beer and skittles. There's some real negatives that you have to draw out or to remind them of. And then there's the art. When do you do that? Do you do that in open session, or do you do that in a private session? So you need to encourage them towards getting a resolution. At the same time, you don't want to take over the dispute. Many people in the first assessment, in my mind, took over the dispute. And one of the ways that it looks to me that you should allow people to keep the dispute is by the way you ask questions. If you ask open, clarifying questions, there's a much better chance that you're going to allow the parties to continue to own the dispute. Now, I say that's important. The parties aren't going to own the dispute if it goes to litigation. It's taken out of their hands. But in an ADR process, and there are varying degrees, I appreciate that, but generally speaking, ADR is a commitment to allowing the parties to own their own dispute. So if you ask closed questions, then you're really taking the dispute away from them. And some of the assessments that I saw, they looked a little bit like cross-examination sessions. And that's not really the purpose of what it is. Sometimes, particularly if there's a lot of private sessions and a shuttle, the mediator or conciliator runs the risk of looking like a commission agent, ferrying offers from one to the other. Now, that's perfectly legitimate in many circumstances, but in my view, it's something that you want to try to avoid if you can. And there's the two problems that I've identified, asking closed questions and ferrying offers from one to the other. You've got to be really careful, because it doesn't take much for there to be a perceived bias in those circumstances, and you don't want to appear to be biased. So think about your body language, think about the way that you embark on the process. So there's some of the general things that I was looking for in the first assessment, and many of the people who did very well, now don't take this the wrong way, but I think that you're very good actors. Now, that's not meant to be a negative. I'm not having a go at anyone, because when I'm in mediation or conciliation mode, I'm not entirely myself, if you understand what I mean. There is a degree of acting. When I'm in court, if I'm cross-examining, if I'm making a submission to a court or a tribunal, there's a little bit of acting going on as well. I'm not saying it's dishonest. I'm not saying it's unethical, but there is a way to embark on that process. And I think it means that you need to just adopt a different persona, perhaps. Now, you may have the sort of persona that naturally fits in with advocacy or mediation or conciliation. But if you don't, you may need to adopt that and work on it. Now, surely someone must disagree with what I'm saying. Any comments? We all happy? It's all good? All right. Tonight I want to, yeah.
Jessica here.
Yes,
just in regard to what you're saying, I found it a bit, because of the time constraint with what we were doing, it was very like shortened version of what might happen in reality. When I did my first recording, it actually went over time, and so I had to go back with my participants and re-record, and therefore my questions weren't as open-ended as perhaps what you're indicating they could have been, and that's one of the dilemmas I found myself in.
I know, and that's a real problem, and I accept that comment, Jessica, because in many real-life mediation or conciliation sessions, the questions that you ask initially may be perceived as being closed, but you still try, wherever possible, try to make them open questions. But sometimes in order to clarify, the question may be a little closed. So I accept that. That's a fair point. All right, now I'm going to attempt to share the screen here, and this year I was fortunate enough to provide a session to, sorry, I'll get there, I'm getting there, to the Queensland Law Society. And when you are in practice, you need to keep up your CPD points. So part of what I did for a CPD intensive was provide a discussion to practitioners so that they could keep up their CPD. Now, can you see the PowerPoint on the screen? No problem with that? Okay. So let's go through that. Just bear with me a sec, sorry. Okay, so that was the initial. In providing the seminar, I'm going to go through this with you now because it's instructive, I think, in providing some feedback on the assessment number 1, but also providing some guidance as to assessment number 2, because the seminar that I provided to the practitioners was all about applying skills in a practical sense in the ADR context. So the important thing is, and this is really part of tonight's or this week's reading, remember, of course, that your paramount duty is to the administration of justice. So you'll need to consider the ASCR for solicitors, or the barristers' rule for barristers, in the context of what you're doing as lawyers in the ADR framework. You need to understand the alternatives, explain the options. Now that's possibly a big part of assessment 2, explaining the options and providing advice. But to do that, you need to understand the role of participants, the basic procedures, and you need to prepare. You also need to know what to do when you get there. So we need to think about the various options, and this is really the heart of assessment number 2. Because if you don't understand all of these options, then in my view, you can't provide appropriate or full advice. Many of them won't fit a particular circumstance, but if they do, part of your role is to consider it. So you'll see that is just a list form of what is in Thompson's book. But there are really 3 main branches to this. The first is facilitative, second is advisory, and the third is determinative. So someone comes to you with a problem. Before you maybe start to think about the specific type of ADR approach that you wish to adopt, you need to think in general terms. Am I looking for something that is facilitative, something that is advisory, or something that will provide a determination? And tonight we'll be looking at the sorts of things that you might consider in that context. But there is a threshold question here, and the threshold question is always, is litigation the most suitable way of dispute resolution, or should it be done by ADR? So I'm really breaking this down, but that's the first step in the flowchart. The client may come to you saying, I want to litigate, I don't want to consider ADR, but they might be the opposite. They might say, I want ADR, I don't want to go to court. But you've still got that threshold question to consider. And of course, the way in which you approach it will be something that might influence the client one way or the other. Remember, of course, that you must consider whether it's Queensland-based or Commonwealth-based, and if so, before you consider litigation, are there any obligations that are imposed on you or your client by law to consider ADR options? So in your options paper in assessment 2, you might want to consider those sorts of things. So what are the things that you would want to discuss with your client about ADR at the first instance? So the question that you may have for assessment 2 might be something like, a client comes to you, you know, you're working in a law firm, a client comes to you, looks for advice. What are you going to ask the client about? Well, always you've got to be upfront in terms of risks, costs, work out what's the best dispute resolution process, and maybe do a mock presentation. Now, can anyone tell me why that might be important, a mock presentation?
What do you mean by mock presentation to the client?
Yeah. So mock presentation is perhaps something where you actually talk about or demonstrate to the client what this is all about. So sometimes if your client comes to you and says, look, I want to litigate, I want to pursue this debt, and you don't think that the client has great prospects, you can maybe play it out for the client's benefit and say, look, this is the way I think this is going to pan out, and kind of present how the case might ultimately turn. That might be something that you use when you're in favour of ADR, or it might be something that you use when you're in favour of litigation. And part of that is involving genuine reality testing. So initially you've got to be upfront with your client. What you don't want is for them to spend a lot of time and money only to find that their case was not a good case because of something. Now, it's mostly your job as the advisor, the practitioner, to think about the things that you might need for a successful piece of litigation or ADR, but also think about the things that might be threats. It's that old SWOT analysis. So what evidence do you need to obtain, when and how to do so? That's going to be just as relevant going into ADR as it is going into litigation. And part of what I'm stressing tonight is that you must prepare for ADR. It's too easy to think of ADR as a soft option in the sense of, look, you've got a legal problem, we could litigate if you want to litigate, there's all these things we have to do, or we could just call a mediation session, rock up and see how we go. That's not likely to get a good result. You need to prepare, and part of the preparation for an ADR session is saying, what evidence do we need, when do we get it, how do we get it, how are we going to pay for it, and things of that nature. So the preliminary discussions that you have with your client may be to seek instructions to make contact with an ADR practitioner, which is, again, part of the likely scenario in assessment 2. And also think about approaching the opponent. See, if you get in first, you can design the session in a way that suits your client. If you're the proactive side, approaching the other side to say, look, I think we should do this or this or this, and this is the way we should do it. Sure, the other side may disagree, but they may go along with it. And sometimes in negotiations, the person who makes the first offer sets the basic outline and parameters. So why not do that when you're considering an ADR option? Bear in mind that you may have to, your client may need to sign an agreement, but ultimately, if you go ADR, you've got to understand the role of the participants in that proceeding. Lawyers must consider the type of ADR, but still allow the client to retain ownership. And part of the ownership is the genogram. When we talked about the situation where you understand the names of the people involved in the process. So maybe in your first attendance with a client, you need to get a genogram so you understand the players involved. The ADR practitioner, of course, is looking for a point of agreement. Now, coming back to assessment number 1, That's something that I was looking for, whether the ADR practitioner was able to obtain some sort of early point of agreement. It's always a good move to attempt to do that. So a mediator works the agenda. I was definitely looking for that. Keep the parties focused on a problem and be energetic and alert. And this is where you need to, I'm really talking about assessment 1 now, you're always looking to pick up on maybe even just a word that allows you an opportunity to move forward, and it gives you an opportunity to discuss something. So, and in assessment 1, I was looking for what you had in your toolbox: rephrasing, reframing, summarising, reality testing. And a conciliator is somewhat similar. The basic process, I was looking for that in the first assessment as well. The opening statement from the mediator, from the participants, setting the agenda. I prefer a first joint session. Many people went straight into private sessions. I understand that does happen. It's not my preferred approach. I prefer not to go straight into private sessions unless you have to, because if you go into private sessions, in my view, you're taking the dispute away from the parties. Give them a chance to speak to each other directly, unless there's some very good reason not to. Then you have your private sessions, maybe another joint session, and just try to encourage the parties to think about what they're looking at, not only from their own perspective, but from the perspective of the other parties. The blind men looking at an elephant, one says it's rope, one says it's a wall, someone says no, it's a tree, it's a fan, a spear, or a snake. So that's just a diagrammatic representation of how people can consider the same thing from different ways, and you've got to try to think about it from the other's perspective. Hardball negotiators. This was something that I saw in assessment number 1, and it might be something that's relevant for assessment 2, because the factual scenario that I give you may involve you trying to deal with a hardball negotiator. That hardball negotiator might be your client, might be the other side. So how do we deal with that situation? What type of ADR process do we use? Now, it's all very easy to say, oh, well, we should do a shuttle. We should not let the parties join each other. But I think we can be more inventive than that. There are ways that we can deal with hardball negotiators. And sometimes that's actually an empowering thing for the other party. A mediator will often put on their radar, not their armour, and they'll call the hardball tactic for what it is. And there are a few ways to deal with that situation. I mean, for example, veiled threats. We saw this in some of assessment 1. You might see it in assessment 2. If you stop selling my ice cream brand in your fish and chip shop, you're going to go broke within 6 months, guaranteed. We've all come across those hardball type negotiators. Well, as a mediator, you say, well, what evidence do you have to support that statement? Can you give me some examples where this has happened before? Now, odds are they can't. And so they've really got no substance behind it, and it's a way of diffusing that hardball statement. You're not taking them on, you're not being aggressive, but it is a way of dealing with the situation. So in the factual scenario, your client may come to you, and it might be apparent that he or she is a hardball negotiator, or it might be the reverse. How do you structure an ADR alternative that deals with that situation? What do you put in place to get the best result for your client? Sometimes you're dealing with a really aggressive party, and with difficult personalities, as a mediator, sometimes you need to absorb the pressure. We saw that in some. Stay calm, always stay calm. Don't react or abruptly terminate discussions. I saw that a little bit in assessment 1. As soon as it was even the slightest hint of personalities becoming difficult, the mediator would jump on them. And I'm not sure that that's the best approach. It's kind of separating the parties. It's disengaging the parties from the process. In reality, sometimes I'll ask them, even through body language, I'll get them to address all that aggression towards me, and I'll just stay calm, absorb it, and then work through it using reframing skills, avoiding direct criticism, and recognize their strengths and achievements, and you'll start to calm them down and bring them around. Once you've got to that stage, you carefully explain the consequences, maybe in private session, and that's where you're starting to move forward. Now, this is really the heart. I keep saying this is the heart of assessment 2. This is an important part of assessment 2, preparation for the ADR process. It's one of the themes for tonight. You must prepare to have a successful ADR process, because if you don't, odds are you're not going to succeed. And bear in mind that people are human, and many disputes arise because communication is poor, or it's accidental, or it's mistaken. So maybe you need to identify that when you're trying to structure some sort of ADR alternative. And part of the preparation involves you anticipating opportunities and anticipating impediments. And again, when you're reading the material, when you're preparing for assessment 2, thinking about what might be there, you need to build this sort of thing in. How do you prepare well? Okay, so firstly, you've got to talk to your client. Make sure your client understands the process that you recommend, is able to attend in person, has authority to settle a dispute. Then think about the evidence. Have you obtained witness statements? Do you need to get an expert report or opinion? And do you need an expert's conclave? Okay, so let's say your dispute is an engineering problem, and you've got two builders, who are in dispute, and the heart of the issue is an engineering one. Do you obtain an expert report or an expert opinion, or do you approach the other side essentially to nominate an individual, one per side, and build in a process where those two experts meet together with an ADR practitioner, no lawyers, no parties, but you build in a process where the two engineers have their own mediation, and the idea of that, which is a conclave, is for them to come up with certain points of agreement or points of disagreement and a statement as to why. So when you're preparing for ADR, think about expert reports, think about an expert's conclave. Another thing you can do when you're preparing for ADR is do some drafting. Prepare a mediation or conciliation statement, an outline of your client's position and interests, and try to come up with a statement of agreed facts and legal issues. You see, the mediation is going to be much more successful, or the conciliation, or whatever type of ADR process you think about, whether it's arbitration or partnering, whatever it might be. If you have an opponent and you can come up with an agreed set of facts and an agreed set of legal issues, it means that you're going to get much more out of the mediation process than if you did no preparation at all. So with your opponent, maybe you come up with those things. A statement of agreed facts, a statement of facts in dispute, or a list of the legal issues. And remember, reducing the issues in dispute is likely to shorten the length of a trial, decrease legal fees, potentially increase the prospects of success if you're claiming costs. And if you're being proactive, you might draft some directions that you think might be appropriate for ongoing conduct of litigation. So the second scenario, so the second assessment scenario may be that litigation is underway. Your client is concerned about the litigation, wants to explore ADR options. How do you best achieve a successful likely outcome? So you might have to undertake a risk analysis. To do that, you might have to prepare a document. And I'll show you something. is the risk analysis to, in that you try to identify legal risks, commercial risks and personal risk. So these are all the sorts of questions that you want to embark on when you're dealing with your client. So the risk analysis, come up, have a list of standard questions. You can use this when you're dealing with the client, when you're trying to create a discussion point with the other side perhaps. Is the law clear? Now, if the law's clear, you might use that to your advantage. If it's not, again, you might use that to your advantage. What are the prospects of success? Are the facts clear? And will your client come up to proof? So when you're speaking to your client about the ADR option, let's assume for a moment that they're hell-bent on going to litigation, they've got a sure winner. You say, yes, but is the law clear? Are the facts clear? Will you come up to proof? Will your witnesses be available and come up to proof? When we say come up to proof, that means will they perform as you expect in reality? And does the other side have evidence that is to our client's disadvantage? And can I rely on some external objective standard? So when you're preparing for ADR, think about whether you can rely on something externally that will clarify the issues or help to resolve the facts. Red Book, for example, is an external object. So prepare your client, and what are the legal fees to date? What are the likely further legal fees? What are the prospects of the court making an order? Additional fees for experts, etc. And if the matter doesn't settle, this is an important one, often overlooked. What's the opportunity cost to your client? What that means is, surely you've got better things to do with your time than be involved in litigation. Forget the direct cost for a moment. What's the indirect cost? How much are you going to lose by involving yourself in litigation when you could be doing something else? I don't see that question asked a lot. Does your client have issues associated with a public hearing, reputation, etc.? So you're then also preparing your client in relation to personal risks. So stress, not only on themselves, but also on their relationships and others close to them. The effect on home life, work performance, and of course on health. So this is all part of the preparation that you're dealing with your client. In a way, it's reality testing. So prepare your client to talk about the tactics that they'll adopt. And I use something like this when I'm speaking to clients, when you're preparing. Now, this is really important to do. You don't have to involve the client, but you've got to think about these things. When you're going into an ADR session, preparation is everything. So what are the issues for your client? What are the issues for the other side? Then what does your client want? Think about the BATNA and the WATNA and those other things. And if you actually document these, it's going to help you prepare for the ADR process in so much better way. So when you're participating in ADR, you need to ask, or the ADR practitioner will ask some questions. Now, I was looking for this in assessment 1. Why hasn't the matter settled? What would help to settle this matter? What risks do you face, and what would you like to get out of it today? So if you are going to be an ADR practitioner, have a few of those sorts of questions in your toolbox ready to bring out at appropriate times. And I was looking for some of these things, obviously in a 15 to maybe 20 minutes, so you didn't have time to do all of these things, but these are the sorts of things that I was looking for in the first assessment. Again, to some degree, subjective. Sponging means soaking up the aggression, the emotional outburst. It's not counselling, it's really just absorbing it. A lot of active listening, open questions, summarising, etc. Reframing, I was looking for that. So reframing is where you get a really toxic statement, you strip it down to the basic facts and repeat it back, and then follow it up with a question to keep it moving. Reframing is a really important technique to develop. So you detoxify something. He's always leaving things around, lying around. So you have concerns about his lifestyle and you want him to know how his actions impact on you. That's what I mean by detoxification. You've got to practice that. Transition to the positive. So you take something that's negative, reframe it, switch it around, make it positive. He never tells me what's going on with the company's finances. So you would like to have direct access to the company's financial records. Is that correct? Yeah, I would. Okay, so we're now moving forward. We've taken a negative, reframed it to the positive. Sometimes we take something from the past, transition to the future. My daughter was such a lovely girl. I don't know why she has become so bitter. So you love your daughter and you want a caring and mutual respectful relationship with your daughter in the future. Again, practice these things. I was looking for it in assessment 1. Transition to interest. Take parties away from their positions and focus on their interests. I cannot live this way with all that noise coming from my neighbour's property. I'm not sleeping. So you like living where you are and you want to maintain your lifestyle. Now, you can ask all these questions when you're preparing for ADR, and that's really the point of what I'm trying to make today. These are not only questions for ADR practitioners, but they're questions that these are techniques that you adopt when you're a practitioner. Ask these sorts of questions so that you're better preparing for the ADR. I can't live this way. I've done that one. Take a shared approach. He's so stubborn, he will not think about how we can pay the school fees. So it's important for you both to consider how to pay creditors. Make it a shared approach. So now let's move on to offers. Now, when you're taking instructions from a client, you want to think about the offers, try to package an offer. And it's really important as a mediator or when you're preparing for mediation that you try to work in a situation where it's apples for apples. So think about all the aspects of the offer so that if it is accepted, it's a complete resolution of matters between the parties. And of course, reassurance is a big thing as well. Okay, so thanks for your patience as I went through that pretty quickly, but some specific skills. Genogram, we did that exercise a few weeks ago. And that's the flow chart that you have in front of you. So in your first appointment with a client, you may want to explore that. And there's a genogram from Love Actually. Okay. Can you see me now again? We're back live. Thank you for your patience as I went through that. Are there any questions or comments?
John, can you put up a copy of that PowerPoint presentation on the Moodle forum, please?
Yeah, sorry, Jason, I just had trouble hearing that.
Are you able to put that PowerPoint presentation up onto the Moodle site?
Oh, okay, yes. Yeah, I think I can do that. So, yep, that's a good idea.
Thank you.
And speaking of Moodle and UCrew, I'm sure you've all seen last year's work. And I encourage you to ask any questions about that. I also encourage you to make comments and don't be afraid to provide some hints and assistance to each other. In other words, I'm not going to treat that as collaboration if it's in an open forum. So when I say that, and I'll try and be as clear as I can on this, this is not the second assessment. I think you've got 4 days. It's not a group assessment. It's an individual assessment. but you can maybe assist each other in general ways without being specific. If you assist, if you do it through UCRU, that would be ideal, because then everybody's getting the benefit. So just keep that in mind. It's not a collaborative group effort, but it's not completely closed either. All right, the other thing that you might want to consider for the second assessment piece, and it is part of your reading for this week, are the ethical standards. So the ethical standards, you really need to know what the governing bodies are. You need to know where to look for some commentary in relation to the ethical issues. And I've given you one tonight, but think about where you go to look for the ethics, and also think about the issue of becoming accredited. So the second assessment may be something in relation to your desire to actually be a practitioner in a certain area. What do? Do you just say, I've got my law degree and I'm now going to be, I'm now a dispute resolution advisor? Is it as simple as that? So think about that. Think about the standards that might apply, and think about the code of ethics that would apply as well. And as I mentioned before, think about Mullen's case. All right, so what I'll do is put up the PowerPoints for tonight on Moodle, and I'll provide some additional hints during the week. Next week will be our last week on Zoom sessions, so there won't be a Zoom session as such in week 12. It'll just be discussions through UCRU. Are there any questions or comments? And I thank you for your patience. Are we all good?
John, I can't seem to get, this is Gordon, I can't seem to get into UCRU. I have an account, but I don't know my password, and it simply won't let me in. So you say it's on Moodle, but I tried Moodle and it simply put me into the YouTube presentation. I didn't get the document.
Oh, I see. All right. So on Moodle, I have the YouTube presentation, and I've also got a short commentary at the top. The document itself is at the bottom of the landing page. That's the assessment, so at the bottom of the landing page. And I'm just puzzled by that link to UCRU doesn't work. So there is the, on the left-hand side, top of the landing page in Moodle, there is that link, and that doesn't work for you, Gordon.
I obviously wasn't looking in the right place. I'll try again with the bottom of the landing page. Thank you.
Oh, yeah. No, thank you, Gordon. All right. Any other questions or comments? And thank you for that, Gordon. All good? All right. Well, thank you for your attendance tonight. Good luck with your preparation for the second assessment. We'll see you next week and we'll chat on UCRU. So all the best, and I'll stop the recording now.